One of our top stories of the day, the Justice Department saying it will review all legal options after the acquittal of a Cleveland police officer found not guilty in the fatal 2012 shooting of two unarmed black suspects after a high-speed chase. Prosecutors say the officer fired 15 rounds through the suspect's windshield after they were no longer a threat. But the judge siding with the defense.
Grillo's entire use of deadly force was a constitutionally reasonable response to an objectively reasonably perceived threat of great bodily harm from the occupants of the Malibu, Russell, and William.
Well, joining me now, criminal defense attorney David Bruno. He's a former prosecutor, and attorney Deborah Blum. Both of them here to weigh in on this issue and the perspective of this case. When you look at it on the surface, many people are left with the question, how is it possible that a judge could acquit a police officer after jumping up on the hood of a car and pumping an additional 15 rounds into a couple that were no longer perceived as a threat?
Sure. Kelly, listen, there was a causation issue as to what shots caused the death of the victims. And that is what the judge explained in his decision and articulated. There were 13 officers on scene that fired shots. 137 shots were fired. There were 4 fatal shots to the male and 7 fatal shots to the female, and the medical examiner, the government, the state could not prove who fired those shots. That was the basis of the acquittal on the involuntary manslaughter. So,
Deborah, what David's talking about is you've got to be able to prove it beyond a reasonable doubt, and the judge is having some leeway saying there was, the state didn't prove its case. However, they chose a bench case as opposed to a jury case. Why?
Well, I'm glad that you brought that up. That's what I wanted to discuss here. They made the decision to have a judge because they knew that this judge was going to give them a favorable verdict. When you have a case where something has gone on like this, where you have 2 unarmed individuals who are shot dead after 137 shots were fired by 13 police officers, you know that a jury is most likely to convict. When there's a judge who faces a tremendous amount of pressure from the police themselves, court officers, corrections, it's difficult for them to actually render a conviction. So here, the police officer and his defense attorneys chose the right solution to get him a not guilty verdict. They elected to have a trial by judge, not trial by jury.
David, the force of this on the surface, again, it was pretty excessive. And here you have 2 African Americans who were apparently caught in a high-speed chase. Apparently they heard something go off that sounded like a gun, and it actually may have been the car backfiring. But be that as it may, they went on a 23-minute ride, a high-speed chase. So maybe there were some indecisive moments there on behalf of that driver. He should have stopped. There's no way around that. However, shots, 130 shots.
Yeah, listen.
And they were
the state was very clear that the other 12 police officers, who they didn't charge, by the way, made the right decision in firing shots. They reasonably feared for their lives and the others. It was here.
Well, he got on the hood of the car after they'd been shot at so many times and fired 15 times into the car. That's clearly excessive force.
Listen, this is a criminal justice procedure. This is reasonable doubt, presumptions of innocence, maybe in a civil context, which, by the way, they have remedies in that venue, or Department of Justice 1983 action. This is criminal. They have to prove it beyond a reasonable doubt.
But
and like the judge said today,
there was a justification here. The judge said justification, but how? After you jump onto the hood of a car and these people are wedged between 2 police cars, you're not justified at that point. There are many other ways that you could get to.
Let me ask something real quickly because we're running out of time here. This is on the anniversary of Tamir Rice, the 12-year-old who was shot also in Cleveland for carrying an airsoft weapon, a handgun, which is a toy, basically. I mean, it's not going to really hurt anyone, but the police officer gets out of the car, rookie cop, opens fire, kills the 12-year-old. The anniversary of that, then compounding with this 2012 situation with 2 blacks being killed, and it appears to be something that now the officer being acquitted. So now you're looking at the fabric of the community already protesting because they feel that an injustice has been served. How do you get over this now with the Justice Department stepping in, what must they do?
Well, the
What can they
legislation
do?
has to take action because this continues to happen. You're seeing young African American males being shot when they're not carrying a gun themselves. How can we explain that a 12-year-old was shot in a playground? There's absolutely no
David,
explanation
final thing.
for
The
that.
mayor of the city today said that the police operate with tolerance. Did tolerance run out possibly in this particular case?
Well, listen, I think this verdict stands for a particular position. All right, let's respect the verdict. Let's take these cases separately. The Rice case is very different than this case.
Much different.
Absolutely.
But we
So
had to bring that in
let's-
because it is part of what's going on in
No
Cleveland
question.
right
Take
now.
a look at the judge's opinion. In the introduction, the first 5 pages, he talks about Rice,
Yes.
how he drives by the site every single day. This was a fair judge here.
All right,
I
we got to leave it
disagree.
on the note. A fair judge, a fair acquittal, and we'll continue to follow the case as it unfolds to see what the Justice Department will do. I want to thank you both. Obviously, not enough time to discuss such a big case like this. David and Deborah, thank you so much.
Thank you,
Thank you.
Kelly. Appreciate it.